There are many branches on the tree of life. There is no one way to be, and there is room for everyone to be who they are. This is a quote that features in the recent landmark Judgement by Madras High Court, in which it called for a ban on conversion therapy, making it the first Indian state to ban conversion therapy. Conversion therapy is an umbrella term for various interventions of wide-ranging natures with a common objective or an aim that one can and should change the sexual orientation and gender identity of LGBTQI+ community members. The belief that they can change the sexual orientation of a gay, lesbian, or a bisexual person to that of a heterosexual person, and the gender identity of a transgender or a gender non-conforming person to that of cisgender. This is a globally frowned upon practice. However, unfortunately, it is still widely available in various medical and religious institutions as well. In May 2020, the United Nations Human Rights Office of High Commissioner issued a report about the same and called for a global ban on conversion therapy. This particular judgment, delivered by Justice A. Anand Venkatesh, suggested a ban on medical professionals who try to medically change or cure the sexual orientation or the gender identity of the queer community. The court directed the National Medical Commission, Indian Psychiatric Society, and Rehabilitation Council of India to take action and withdraw the licenses of professional medical practitioners who are involved in any form or method of conversion therapy of the queer community. Apart from this, the court also laid down a slew of guidelines which include introducing gender-neutral washrooms for gender non-conforming students, to making it procedurally easy for transgender people to change their gender and name on academic records, and to also introduce separate presents for transsexuals. These directives have far-reaching consequences and are issued by Justice Anand Venkatesh after he willingly underwent psychoeducation under qualified counselors to better understand the issues of same-sex relationships before writing the 125-page judgment. This current case deals with a Madurai-based lesbian couple aged 23 and 20 years old who live as a married couple. Facing objections from their family, they fled to Chennai and took refuge with an NGO. But they continued to face police harassment based on the complaints filed by their parents, so they moved to High Court to stop cops from harassing them. Based on this, the court has observed that LGBTQI+ persons are entitled to their privacy and, I quote, have a right to lead a dignified existence, which includes their choice of sexual orientation, gender identity, gender presentation, and gender expression, and choice of partner thereof. This right and the manner of its exercise are constitutionally protected under Article 21 of the Constitution. The court said that when police officers investigate missing cases of man or of a woman, should drop those cases when they discover that these concerned individuals are consenting adults of queer community. And the court also directed the union and the state government to issue policy changes to change the curriculum at schools and universities to educate students about the LGBTQI+ community and the issues faced by them. The court has directed the union government to devise policies to eliminate prejudice against the queer community and devise public awareness programs especially directed towards the judiciary, police, public servants, and professional medical health practitioners and parents of the people who belong to the LGBTQI+ community. Justice Anand Venkatesh also advised the union government to enlist NGOs and community-based organizations who are better equipped and have expertise in dealing with issues related to queer community, and said that any person who faces an issue for the reasons of their belongingness to LGBTQI+ community may approach any of the enlisted NGOs for safeguarding and protection of their rights. The court also highlighted the need for having this sort of an awareness in judiciary, and hence the court directed the law ministry and the legal service authorities to educate judicial officers at every level by working together with NGOs and community-based groups to educate judicial officers about the prejudice faced by the queer community and recommend them policies to eliminate discriminations against them and how to safeguard their interests. The court also observed, through parent-teacher association meetings, sensitized parents on issues of LGBTQI+ community and gender non-conforming students to ensure supportive families. And asserting that this issue involves regular monitoring, the court has adjourned the matter to August 31st to issue further orders. This case marks an important movement in queer rights movement in India. We have come a long way from a justice in Delhi High Court asking the question, do you know any homosexual person? I don't know any homosexual person, while presiding over the case about the unconstitutionality of Section 377. To this point today, when a judge in a high court, Madras High Court, undergoes psychoeducation under qualified counselors to better understand the problems of queer community to deliver better inclusive judgments. And this also comes at an important point in the year, in the month of June. June is celebrated as the Pride Month, where we celebrate the queer community and the queer rights movement on a global scale. This also marks the commemoration of the anniversary of Stonewall riots in New York in United States, which is an important milestone in the global queer rights movement. This isn't the only inclusive judgment by the Madras High Court. In April 2019, the Madras High Court banned performance of 6 selective surgeries on intersex infants. So this marks that there is a progressive, inclusive future ahead for the queer community in India. And this renews the hope of every